certificate, right? But you go through a couple other things there, right? You talk about, for example, sentencing, for example, okay, where what would let's say that you're dealing with another scenario where there's a significant period of incarceration. How might the breach affect that?
Well, I give an example again using an impaired driving or any case where there's statutory minimum penalty of jail or a fine. Well, the Supreme Court of Canada has told us that in a case called Nasa Gallia, that you can, it is open to the defense to ask that the court, as a charter remedy, reduce the sentence to below the statutory minimum.
Right.
So you can do that. Actually, for ordinary sentence reductions, you don't have to prove a charter breach, but obviously if the misconduct of the police is so bad that it rises to the level of a charter breach, you should be looking at a pretty good sentence reduction.
Right.
The other thing I mentioned is damages and costs, but I used to ask for damages, I used to ask for costs. I don't anymore.
Why not?
Because I don't think I want to give the judge that easy out.
Right.
And I don't think it's really a proper remedy. If it's bad enough to warrant a charter remedy, then I think the remedy should be a stay. But having said that, I could see a judge saying, well, you know, I'm not going to stay this prosecution, but I'm going to award $5,000 in damages. That could happen.
Right.
It has been known to happen.
Right. Okay. Now let's move back a bit. I think we went through this kind of quickly there, but there's some cases where, and you cite the section numbers here, where it can be a substantive defense, not necessarily for impaired, but maybe for an assault PO, obstruct PO, disarm PO, these types of things. Now, if you're sitting in law school right now or you're a young lawyer, you may not automatically know what those are. What do you mean by substantive defenses?
Okay. So, for assaulting a police officer or obstructing a police officer, it is an essential element of the offense for the Crown to prove that the officer was acting in the lawful execution of his duty. If an officer is using excessive force, he is not in the lawful execution of his duty. He's in the unlawful execution of his duty. Now, the interesting thing here is that normally, the onus is on the accused to prove on a balance of probabilities that charter rights have been breached. But if lawful execution of duty is an essential element of the offense, then my view is that the onus is on the Crown to prove beyond a reasonable doubt that there was no excessive force. The other thing is, in excessive force cases, the onus is always on the Crown to prove that the force was reasonable on a balance of probabilities. So the burden of proof and the standard of proof is different than if you're just bringing an ordinary charter application. So I think that's a tough standard for the Crown to meet when there is force being used. And in many cases it's very tough for them to meet it. I don't know if judges have really got their minds wrapped around that yet, because it's a little twisted logic and it's counterintuitive, but that is, I'm sure I'm on solid legal ground on that point.
Okay. All right. Now let's talk a little bit of here. You go over. We've covered a lot of this here, but you also talk about you're of course very involved in the Alberta Bar, and you keep, on behalf of one of the organizations, on the Edmonton organization, you keep a police database.
Right.
Okay, and you list your email specifically there. So could you, let's say that hypothetically a young lawyer or a law student, probably more commonly a young lawyer, finds out something about this, and this is probably more for the Alberta crowd, this will go up on the internet, but we're probably more addressing this to the Alberta crowd. Let's say that you get a file, you're in Red Deer, you're in Bonnyville, wherever you're at, okay, and you learn that, well, this cop seems to be a bit heavy with the baton, right? Or there's a problem like that. To explain to me how the database works. Explain to me what that is. How would that work?
Okay, well, there's two aspects to this. Number one is the CTLA is amassed in this database
Right.
a lot of information. Many officers who have folders where we have entered information about their misconduct.
Right.
So the lawyer wants to know if there is any misconduct on the part of an officer they're dealing with. All they have to do is email me,
Right.
and I'll tell them.
Right.
Secondly, this database obviously relies on information being provided by lawyers. And so I'll tell you, sometimes I'm sitting in the cafeteria at the law courts, some lawyer is telling me about some case where there's terrible excessive use of force, even where a judge has found it was excessive force, and I say, well, that's really interesting. Why didn't you tell me about it?
Right. Right.
Because, and frankly, I just give them hell because, I need this information. Our firm needs the information. If you give us the information, we'll enter it on the database. I need to know the docket number,
Right.
the regimental number and the name of the officer, and a summary of the information that I can put on the database so that, the next person who encounters that officer will have a lawyer who will be able to ask me for that information. Because you can bet your bottom dollar that 99.9% of those cases where an officer has used excessive force, your client's not the first guy who suffered it.
Right. Okay. Now, you make a reference a little bit over there, and this is a term in your brief at point 7. You talk about something called McNeil disclosure, and that's probably something that a lot of people in law school may not know, or the younger lawyers may not know. Could you explain to me what McNeil disclosure is?
Well, McNeil's the name of a case from the Supreme Court of Canada, which established that where there have been misconduct findings against an officer in 5 categories, which everybody calls the Ferguson 5,
Right.
in 5 categories, then without prompting, the Crown must disclose that. And so the problem is that there's a lot of misconduct information out there that is not McNeil disclosure.
Okay.
For example, what I just said, if some judge found that an officer used excessive force in a case, that's not going to be McNeil disclosure because it wasn't in the disciplinary context or the officer wasn't prosecuted for it. And there's a lot of misconduct that the Crown or the police will take the position, oh, it's not serious enough to be a Ferguson 5,
Right.
or too much time has gone by, so we don't have to disclose it now.
Right.
And so that's where it's really valuable to have the stuff on the database because it's going to be there forever on the database.
Right. And just, you made reference to the Ferguson 5. Okay, tell me about that.
Well, Ferguson 5 is oh boy.
Yeah, you don't have, I can drop
Well,
it.
Ferguson 5 is basically where let me talk about the most important category.
Sure, yeah, definitely.
Where there are charges that have been laid,
Right.
either under the Police Act,
Right.
or under the Criminal Code, or
Right.
some other criminal statute, or where there have been findings against the officer under the Criminal Code or
Right.
criminal findings, or there have been findings under the Police Act or the RCMP Act, matters which are of a serious nature.
Okay. All right. Fair enough.
Now, the other thing that McNeil says is that if there's an investigation going on about an allegation of misconduct which relates to the subject matter of the prosecution, then they have to disclose that too. So, I'll say something about that. If you make a complaint, then they have to investigate it. Police have to investigate it.
Right.
All of the evidence that they gather has to be disclosed to the defense in the course of the criminal prosecution.
Right.
So it's a tactical question. Should we complain right away?
Right.
Or should we wait until the criminal trial is over?
Right.
Because maybe you don't want to show your hand.
Right.
You don't want the police to know exactly what your client is saying happened. You go to trial, you catch them by surprise.
Right.
So
Okay.
I do it both ways, but more often than not, I wait.
Okay. All right. Fair enough. Now, you in part 4 of your brief, you talk about filing a constitutional notice of constitutional argument or a charter notice. Okay. And that, of course, has broad application, throughout criminal law. Okay. Tell me about that. Okay. And again, keeping in mind you're probably talking to a few law students and junior lawyers. What is that? What kind of thing would that be?
Well, so there's a notice of constitutional argument that you have to file in provincial court under the constitutional notice regulation.
Right.
So it is setting out in some pretty good detail what the allegations are, what the specific sections of the charter are that have been breached, and then you have to list your cases that you're going to rely on. And you have to do that if you're going to raise these charter arguments. So, and then of course in the Court of Queen's Bench, that regulation doesn't apply, but it's called the Dwornichuk notice, so you have to, I just basically file the same thing in the Court of Queen's Bench.
Right. Okay. Which actually dovetails very very nicely. You also talk about it.
Now,
Sorry. Go ahead. No. By all means.
Before I forget,
Yeah.
if you got a fellow charged with intoxicated in public, a ticket matter. Okay, so speeding. Let's say your guy is speeding and gets beat up by the cops.
Right.
Well, you can still raise these excessive force arguments.
Right.
As soon as you do, though, as soon as you file in traffic court,
Right.
it's out of traffic court because the traffic commissioners have no charter jurisdiction. So that lands you in provincial court criminal.
Right.
And quite often that means that the ticket will just go bye-bye.